Welcome in, everybody. Before we get into this late night update, I want to go over a quick synopsis of why I decided to come on and do this. I discussed this in the live, but for everybody on TikTok and for everybody on YouTube who doesn't want to watch the entire live, the SEC has had a response now in regards to the overturn of Judge Annalisa Torres's decision, and they said this. So in the SEC versus Terraform Labs Duquan case, the SEC has filed a pleading discussing Judge Torres's decision in SEC versus Ripple, in which it states that SEC staff is considering the various available avenues for further review and intends to recommend that the SEC seek such review. Pleading below, SEC says XRP ruling was wrong, signals it will appeal. Now I have official document number 49. It was released on July 21st, 2023. So today it's a 6-page document, and it goes over the entire thing with the Ripple and what the SEC thinks was wrong. So we're going to go over this. I might have to release it in 2 parts on TikTok, but I'll release it in 1 part on YouTube. Make sure you hit that like button and subscribe if you appreciate my work. But this is breaking news, so I figured I would give you what everybody's talking about, but I would give you the facts so you can make an educated and informed decision. If you're an XRP holder, stay strong, my friends. Do not sell. Do not sell. There's a lot of adoption going on, and just to prove that, this is something I'm going to share in a little bit, but Ripple boasts new partnership to test issuing crypto CBDCs and stablecoins. As that's happening, when they announce that, this is the SEC. So you got to make an informed decision. Don't give up your XRP for anything, folks. United States District Court, Southern District of New York, and this is official document 49 filed on July 21st, 2023, page 1 of 6. We'll go over all 6 pages. After 10 minutes on TikTok, I'll release it in parts. United States District Court, Southern District of New York, Securities and Exchange Commission, Plaintiff Terraform Labs PTE Ltd, and Du Haiying Quan, Defendant, Securities and Exchange Commission response to supplemental authority in support of defendant's motion to dismiss. Plaintiff, Securities and Exchange Commission respectively responds to defendant's submission regarding a summary judgment ruling in a different case pending in this district. The court considered whether sales of a crypto asset called XRP were sales of investment contracts under SEC v. W.J. Howey. The court concluded that Ripple's sale of XRP in so-called institutional sales, i.e. those made directly to certain counterparties pursuant to written contracts, were offers and sales of investment contracts, programmatic sale, but that it's programmatic sales to less sophisticated investors on digital asset exchanges, and certain distributions of XRP for services were not. Contrary to defendants' assertions, much of the Ripple ruling supports the SEC's claim in this case and rejects arguments defendants have raised here. However, with respect to the programmatic and other sales, the SEC respectfully avers the Ripple conflicts with and adds baseless requirements to Howey and its progeny. Respectfully, those portions of Ripple were wrongly decided, and this court should not follow them. SEC staff has considered the various available avenues for further review and intends to recommend that the SEC seeks such review. Page 2 of 6, Ripple's holdings to institutional sales supports SEC's argument here. Ripple's rejected 2 arguments defendants make in their motion to dismiss here. First, defendants argue that Howey requires that the purchaser of an investment contract have a legal entitlement to share in the profits of enterprise. Defendants' argument that all investment contracts must include post-sale obligations as the promoter and grant the investor a right to share in profits from the promoter's efforts. Second, defendants argue that the SEC did not provide defendants with fair notice of its retroactive interpretation of securities laws it now asserts in this case. But Ripple rejected that defense, finding that Howey set forth a clear test for determining what constitutes an investment contract. Defendants assert a hodgepodge of purported factual differences between their crypto asset sales and Ripple's institutional sales, but none of those purported factual distinctions are sufficient to distinguish defendants' sales from Ripple's for purposes of Howey, given the amended complaint's detailed allegations of statements that led investors to reasonably expect profits from defendants' efforts. And on a motion to dismiss, the courts must draw reasonable inferences in the SEC's favor, including that the institutional buyers in this case, such as trading firms that purchase defendants' crypto assets with no restrictions on resale, purchased because they viewed the asset as an investment opportunity in Terraform's efforts 2. Ripple Holdings as programmatic sales, in this page 3 of 6, is incorrect and should not be followed. By contrast, Ripple's analysis of programmatic sales cannot be squared with Howey and decades of federal securities laws jurisprudence. This court should not follow it. Ripple correctly concludes that defendants' extensive public statements promoting XRP created an institutional buyers reasonable expectations of profits from Ripple's efforts. The same results should have followed directly with respect to retail buyers too. Instead, Ripple creates an artificial distinction between the expectations of sophisticated institutional retail investors and properly transforms Howey's reasonable investor inquiry into a subjective one and turns on its head the reasoning underlining Howey and other cases. First, what an investor reasonably expects does not depend on whether the investor buys into the investment directly from or communicates directly with the promoter. The promoter's choice of using intermediaries to sell does not alter reasonable expectations. Those who buy indirectly have the same reasonable expectations. Those expectations arise from the promoter's same public statements and from the same economic reality of the investments, and not from how mechanically funds flows to the promoter. In other words, when investing, even through impersonal transactions, a reasonable investor would have understood that she was buying into the promoter's touted efforts to develop the investment. Thus, Section 5 expressly prescribes offers to sell as well as sales made, directly or indirectly through intermediaries, and courts have found Section 5 violations where unregistered securities transactions occur through the use of intermediaries, showing that Ripple's direct purchase requirement does not exist. Second, Ripple erroneously creates two different reasonable investor standards, one for institutional and another for retail investors, but creating any subjective dichotomy is contrary to Howey. In concluding that the programmatic sales did not constitute the offer and sale of an investment contract, Ripple considered whether those generally less sophisticated investors could properly parse and comprehend the promises made to them. But investors' subjective views are not determining, and to conclude that the SEC must prove investors' specific knowledge of particular statements would improperly require the SEC to show reliance in its enforcement actions. Third, Ripple misconstrues the efforts of others' analysis in other ways. This prong is meant to identify whether the efforts made by those others than the investors are the undeniably significant ones, those essential managerial efforts which affect the failure or success of the enterprise. But Ripple appears to improperly add requirements to this analysis, including that the seller have made promises directly to each investor, that each investor knows that her money was going directly to the promoter, that the expectations as opposed to the profits derived from the issuer's efforts, and that the investor believed that her proceeds would be used directly to undertake the relevant efforts. These factors are plainly not a part of the Howey analysis. Finally, the underlying logic of the Ripple ruling is divorced from the basic principles behind Howey and federal securities law. More broadly, when distinguishing between, in this page 5 6 classes of investors, courts construe the federal securities laws provisions to provide more, not less, protection to retail investors. When courts applying Howey analyze a market of dispersed retail investors, dispersion makes it more, not less, likely that the reasonable investors expected profits from someone else's efforts. When courts consider the impersonal nature of security solicitations in the modern world and securities markets, the impersonal nature of security solicitation in the modern world and securities market, they reason that drawing distinction between personal or individual solicitation makes little sense and will permit sellers to dodge liability through choice of communication. When courts construe the federal securities laws, they are generally mindful of the impersonal nature of secondary trading markets, and Howey's objective standard presumes that investors are aware of all information reasonably available to them. Courts look to the economic inducements held out in promotional materials and promoters offered are judged as being what they were represented to be. Looking to expectation of a reasonable investor as prompted by promoters a standardized representation. Ripple's reasoning is impossible to reconcile with all of these fundamental securities law principles. I'm shocked we got through this in one 10-minute session. So this is page 6 of 6, dated July 1st, 2023, respectively submitted Christopher J. Carney, Jorge G. Tenorio, Christopher J. Carney, J.P. Connor, admitted pro hac vice, Laura Heath Meekin, Devin Ellis Therum, admitted pro hac vice, attorneys for plaintiffs, U.S. Securities and Exchange Commission, 100 F Street, New England, or Northeast Washington, D.C. 20549. So this is the official document number 49, page, all 6 pages, read right for you so you have the information.